Now the question arises, can the court exclude evidence that is relevant and otherwise admissible? So, court can exclude evidence that is relevant and otherwise admissible on the grounds of the fairness of the case, n- to not to cause any prejudice against the defense. Court can exclude the evidence that is relevant and otherwise admissible. The extent of judge's discretion to exclude evidence in criminal cases will be considered in several contexts during the module in the future. The judge can exclude relevant and admissible prosecution evidence in the interest of fairness, because of the fact that when something is not allowed by the court of law, like phone tapping is not allowed by the court of law, evidence gained through phone tapping is could not be used to prove the prosecution case, and court will have to exclude that evidence so that prejudice is not done against the defense. But the judge has no discretion. This is important. The judge has no discretion to exclude relevant and admissible defense evidence. So, if defense evidence is relevant and admissible, court cannot exclude it. This rule only applies to prosecution evidence. So, prosecution evidence at common law, there is a discretion to exclude the evidence which is more prejudicial than probative. Evidence of admissions and confessions and other evidence obtained from the defendant himself after the commission of the offense by improper. So the evidence was taken by improper and unfair means, and which might operate unfairly. It shall operate unfairly against the defense. So that is why court can exclude the evidence. Court has the power to exclude that evidence. Court has the discretion to exclude that evidence. So, using her common law powers, a judge might exclude photographs of injuries caused by child cruelty where the injuries can be proved in less inflammatory manner. So, court may exclude the evidence where it could be proved, where facts could be proved by some other area of evidence which is less inflammatory. There is a danger that prejudice caused by photographs will far outweigh the simple facts of injuries which they are intended to prove, and she might exclude an admission made by defendant in the back of police car where he was questioned aggressively without being cautioned, with a solicitor present and without the conversation being recorded. All of this is given in the procedure that the police officer should follow before investigating and interviewing the defense. The common law discretion has been largely superseded by Section 78 of Police and Criminal Evidence Act base. Under Section 78, judge can exclude relevant and admissible prosecution evidence if, having regard to all circumstances, during the circumstances in which the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of proceeding that the court ought not to emit. So, if it has the adverse effect on the fairness, it wasn't gained, the evidence wasn't gained through fair means, so the court has the power to exclude that evidence. It is given in section 78 of the PACE Act. But the defense evidence, the judge has no discretion to exclude defense evidence which is logically probative. So this exclusion of evidence only applies to prosecution evidence and not defense evidence.